The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Thank you, Sarah. Good afternoon. Welcome to the Fourth Circuit. We're ready to hear argument on our first case, 20-6972 Ham versus Breckon. Let me note that for reasons we're not quite sure of, both the public defender and the government have allotted the full-time slots, but since you're more or less on the same page for this appeal, we would encourage you not to repeat each other's arguments unless you think they're particularly useful. So with that admonition, Ms. Lorish, we'll be glad to hear from you.
Thank you, Your Honors. May it please the Court. Starting in Wheeler, this Court outlined a clear four-part test for when a petitioner may use the Savings Clause to challenge an erroneous sentence. None of this Court's cases have required a petitioner to rely on a new, for Teague purposes, rule to challenge a sentence in this way. Instead, the test from Wheeler requires, in relevant part, that a petitioner rely on a rule that changed the settled substantive law, and also that the rule have been deemed retroactive. The three other circuits that permit similar challenges to a sentence through the Savings Clause all agree that Mathis changed the settled substantive law for those petitioners, and that those claims were previously foreclosed before Mathis, even though Mathis was a rule that interpreted and applied past precedent. And this Court should readily find the same. The consistent requirement in Wheeler, Lester, Young, and Braswell is that a petitioner only need to rely on an intervening decision that lifted a barrier that previously existed in this circuit. And that is what Mr. Ham has done by relying on Mathis in this 2241 petition. Prior to Mathis, the circuit's law was clear that multi-location burglary offenses were divisible as to the location of the burglary. That was true for South Carolina burglary, as this Court held us back as 2006 in the Anderson case, and all the way through the McLeod decision in 2015. It was also true for Virginia burglary, which was a similar multi-location burglary offense. In Foster, this Court held that Virginia burglary was divisible, and in Castanet-Lewis, this Court held that Mathis abrogated Foster. Mathis was the decision.
Ms. Lorish, I think you said you're relying on 6th, 7th, and 9th Circuit law, correct? Do any of those circuits require a change in settled substantive law that has been deemed retroactive in the way that Wheeler does? Isn't Wheeler slightly different?
Your Honor, it's true that Wheeler is the only court, the only decision that has put the word substantive in with settled law. But I don't think it's a distinction that causes a difference in this case, because Mathis is clearly a substantive decision, and this Court has applied it to have changed the settled substantive law. And this Court isn't the only one to have done so. Several other circuit courts have found that Mathis changed settled substantive law as well. We see in the McCormick decision. I'm sorry, Your Honor.
Ms. Lorish, let me describe how I look at the arguments that all the parties have made, and perhaps come at it a slightly different way. I guess I would begin by noting that in Wheeler, as Judge Thacker just pointed out, there is a clear requirement of settled substantive law, and I think that requirement is derived from the earlier decision in Jones. So when I look at Mathis, particularly with the number of times the Supreme Court's basically said, to characterize it in colloquial terms, we've been telling you lawyers and judges this for years. This is a categorical approach. This is how we use it. We've done it time and time again. You all just don't seem to get it. So that at best it was a procedural rule. but even accepting that Mathis is a procedural rule, for purposes of the Wheeler test, which with great respect for my good friend Judge Thacker, I still disagree with, but it is the law of the circuit, and so we go where Wheeler directs us. So it would appear to me that there's an argument to be made that even though Mathis was procedural, that cases come after that and take the procedural provisions and apply it to make a substantive law change. So if we look at our decision in Miller, that followed Powell. Because in Powell, we had determined that the Carachuri decision from the Supreme Court was procedural. In Simmons, Carachuri was taken and used to make a substantive change in the law. So when Miller looked at it, it said that even though Carachuri was a procedural change, which I think analogous to this case would be somewhat like Mathis, the substantive changes came later. So in this case, in the Hall decision, even though it's unreported, that would appear to me to be a substantive change. It took on its own terms, it took the Mathis procedural framework and made a substantive change to say South Carolina burglary is no longer a crime of violence. And by doing so, arguably, this meets the Teague v. Lane requirement because if there is a substantive change and it has altered the range of conduct. People like Mr. Ham, who would have faced the ACCA crime of violence restrictions at the time of his conviction, would no longer, after Hall, fall into that grouping. So sorry for the long monologue, but it struck me going through here that perhaps the parties were looking at the wrong case to determine what was substantive.
Well, thank you, Your Honor. I would start by agreeing that I don't think that the Wheeler test requires the decision, what I would call the intervening decision, to have itself been a substantive decision. I think I agree with the theory you've espoused, as I understand it, that a procedural decision could still change settled substantive law. But I don't think the court needs to find that in this case, because Mathis, I would argue, is a substantive decision. And it's a substantive decision, and I would first note that every other court that's looked at it, that's found Mathis applied retroactively on collateral review, has found a substantive decision. But it's substantive because, like other decisions that interpreted the reach of federal sentencing enhancements, the rule from Mathis alters the range of conduct the law punishes, and not only the procedures used to obtain the conviction. And that's the relevant test here from the Supreme Court's decision in Welch. And I think it's clear that Mathis narrowed the predicates that qualify as violent felonies for the Armed Career Criminal Act. It narrowed the definition of burglary in this instance as it pertains to Mr. Ham. So I do think that Mathis is a substantive rule. And then because it's a substantive rule, it ultimately doesn't necessarily matter whether it be a new rule or an old rule, because substantive decisions apply retroactively for cases on collateral review. And again, I think the most important tell in this case is how this court and the other circuit courts of appeals have interpreted the law after Mathis, and have repeatedly found it changed settled substantive law, both for the multi-location burglary offenses we've already discussed, but also in other contexts. The First Circuit in Faust, for example, found that Mathis had changed resisting arrest and an assault and battery on a police officer offense. The Fifth Circuit in Gomez-Perez, Mathis had required overruling a prior case that involved Texas assault.
Counsel, if I could interrupt you, please. Thank you. I'm sorry about that, but I want to return to, I think, something that Judge Thacker may have been talked about earlier. which is I'm trying to make sense of the language in Wheeler that says was deemed retroactive. I mean, that's what the law, the case says. And I think that presents this question, whether you have to have a case that expressly says for what that the specific area we're looking at has been deemed retroactive, or whether the pre-existing law that says, either, substantive laws or procedural laws that, narrow the range of conduct, automatically are retroactive. So the real question is, a question I have is, was deemed, just looking at it, technically suggests there ought to have to be a case that does the deeming and says it's retroactive. Are you suggesting that's not the case if this falls in the category of cases that, as a general rule, are automatically retroactive?
Your Honor, I think that the test in Wheeler doesn't require that it be this court that has deemed a case apply retroactively. I think the district court could have, in this circumstance itself, found that that Mathis applied retroactively, or could have relied on other circuit courts that have held the same. But ultimately, to the extent the court's concerned about this issue, I would suggest the approach Your Honor took in drafting the opinion in the Young versus Antonelli case would apply equally here, and that this court could now deem Mathis to apply retroactively and reverse and remand with that instruction to the district court. And I don't think that the circumstances are distinguishable. That would be an option the court would have if it finds that this court must be the one to deem it retroactively before it's a timely petition by Mr. Ham.
Well, does a court have to do it, really, is my question. Whether it's us or a district court, does a court have to do that, or are we allowed to say that the general law that makes decisions like this arguably retroactive, is that sufficient? Do you have a position on that? And particularly given the language of Wheeler.
Well, Your Honor, I think the decisions that are of the kind that Mathis is, it's based on existing precedent, although it extends that precedent, could be held under the case law to automatically apply retroactively. At the same time, I'm sensitive to this court's prior decision in Braswell versus Smith that suggests that there is a distinction between a new decision being issued and when it's deemed retroactive. So I suppose I don't have a strong answer for the court as to which it has to be in this circumstance.
Okay. One follow-up, and in some of your discussion and in some of Judge Agee's discussion, I think it's probably fair to say that the law of our circuit with respect to third-degree burglary changed. I mean, Kirksey and cases existed that said apply the modified categorical approach, and after Mathis, the Hall decision says the opposite. Is the satisfaction of the Wheeler test dependent on us having that type of situation? Prior case that says something, and then a subsequent case that says something, directly opposed to it. In other words, we're changing specifically our precedent. Doesn't Wheeler require that if we're talking about the change of the law of this circuit?
Well, Your Honor, I don't think that this court would need to reach the full contours of what a change in settled substantive law looks like in every case to clearly find in this case, as Your Honor has suggested, there's a very clear change. We have one decision saying that Mathis has abrogated the reasoning from a prior decision. And we see that not just with respect to South Carolina burglary, but also Virginia burglary, which was the similar multi-locational burglary offense. So I think that we don't have to answer the broad question to resolve it in Mr. Ham's favor in this case because of the clear laws the court noted with respect to South Carolina burglary. So there are no further questions, I would ask this court to reverse with the instruction that the court should allow Mr. Pam's 2241 petition to go forward because Mathis is retroactive and it did change the settled substantive law for Mr. Pam. Thank you.
All right. Thank you, Ms. Lorish. Do either Judge Thacker or Judge Quattlebaum have any more questions at this time?
No, thank you.
I don't think so. So, Ms. Bockhurst, we'll hear from you before we hear from Ms. Barber.
Your Honors, I think if I could just jump in and respond to the questions that have been asked, because I feel like I have slightly different answers than Ms. Lorish to several of the questions. Judge Agee, when you addressed your question about the substantive law change, I think what you explained is exactly correct, that this situation is like Miller and Powell. I think that our position would be that Mathis is both procedural and substantive, actually. If I could back up a little bit, the means versus elements analysis in there is clearly a substantive analysis about how to apply the law. That in and of itself does not make any substantive changes in the law. But Mathis is also a substantive case to the extent that it reversed the applicability of Iowa burglary as a predicate offense. And so clearly if a defendant had been convicted of an Iowa burglary and that was a predicate ACCA, the law substantively changed as to him by Mathis. So Mathis isn't itself the substantive change in law that reaches Ham, but this court's application of Mathis creates substantive cases, creates intervening substantive law that clearly changes established precedent that then makes the whole Mathis line of cases applicable to Ham, and it puts him outside of the scope of the ACCA predicate. And so
Okay, so wait, can I make sure I understand the distinction there? So whereas Ms. Lorish, I think argued that Mathis was a change in settled substantive law, for the government is saying Mathis was not a change in settled substantive law, but the way Mathis has been applied did change settled substantive law? It
changed settled substantive law as to Iowa burglary. And then the way the procedural analysis of Mathis has been applied changes settled substantive law. I think that's correct because it leads into Judge
so the government's brief at page 17 says Mathis did not provide anything new. So if Mathis did not provide anything new, how could it be a change in substantive law?
So Mathis did not provide anything new with regards to Taylor, except for that it provides explanation of how to apply the Taylor analysis. And it clearly leads to reconsideration of numerous burglary offenses and other predicate offenses and the divisibility analysis, and the subsequent cases change the settled law. So because Mathis, the portion of Mathis that's relevant to this case, which is the means versus elements test, is a clarification of Taylor and DeCamp, that is what makes it an old rule. And because it
if I could just to kind of follow up, I think on Judge Thacker's question, is your argument that to the extent Mathis is substantive, its determination of whatever state it was, Iowa, this burglary statute, that was substantive in that context?
Yes, sir.
Is that correct?
Yes.
Because all the other, whatever other states there were, in this case, in the case we have, South Carolina, they're all going to have different elements than however the Iowa statute was written.
Yes. And so savings clause, getting to Judge Quattlebaum's second question, it ties in exactly, because savings clause relief should not be afforded to a defendant unless he can show that some court, this court or the court in which the conviction came from, has determined that the effect of Mathis is to change the conviction's predicate status. So savings clause relief does not become available until this court has already ruled that South Carolina burglary is no longer a predicate offense in light of Mathis. And that is the relevant change in substantive law that has to be shown to get through the savings clause door.
So is that what happened in the Hall case?
Yes. And then the other question that I think I have a slightly different answer to is that I think it is correct that because it is an old rule, for the purposes of Wheeler, it's deemed retroactive as soon as a court rules it is an old rule. And I think the same would be true if the finding is it's a substantive rule. But even for old rules, it's easier because if the decision is an old rule, it automatically applies on collateral review. You don't need to do that second analysis of whether an exception applies. So once it's an old rule, then it has by definition been deemed retroactive for purposes of collateral review because Teague and Wharton instruct that all old rules apply on direct and collateral review. And so I don't think that when you're talking about an old rule, that you need an intervening decision like you do under 2255 F3 that says this decision is retroactive. That's slightly different from a new rule, which the presumption is new rules do not apply in collateral review unless they meet one of the Teague exceptions. And then in that situation, you would need a court to rule that it is in fact a substantive change in law or a watershed procedural rule that gets you applicability on collateral.
So if Mathis is an old rule, would that old rule have been applicable when Mr. Ham was originally sentenced?
Yes, and that is the key point. That old rule was applicable when Ham was sentenced, but the existing precedent regarding his predicate offenses foreclosed his arguments. And so he could have argued the means versus element distinction, but he could not have succeeded because the binding precedent at that time was that South Carolina burglary was a valid predicate and remained so until after Mathis when it's reversed by Hall. And so that is why he fits into the first and second prongs of the Wheeler test, because the settled law of the circuit established the legality of his conviction, but because Mathis is an old rule, it's the rule that should have been applied, so his sentence never should have been lawful, which is what distinguishes it from someone raising an Alene claim, because under Alene, the sentences were lawful at the time, and that is not a retroactive change in the law, so it's still a lawful sentence. Whereas in Ham's case, his sentence was understood to be lawful, but the Supreme Court has made it clear it is not lawful now and it wasn't lawful at the time, and that the settled circuit law that was applied to him was wrong.
Counsel, it sounds like you in clarifying your position with respect to some of the questions Ms. Loris provided, or answers she provided, indicate that precedent that automatically determines certain types of decisions retroactive satisfies the was deemed in Wheeler. I mean, I guess I can understand that reading, but I think you could. In fact, I think this is what the amicus position is, that was deemed suggests something other than an automatically automatic result, and you have to under the law, only a new rule has to be deemed retroactive. Why isn't that why doesn't that teach us that Wheeler is referring only to new rules, particularly when you look at Jones, which specifically says that? Seems to me, one would question why you would have a different and an even broader approach to change of sentences than you do for convictions. And I think I'm not sure what's right, but I think it's not an unreasonable position in light of Jones and in light of was deemed to say that implicitly means it applies only to new rules. Why? I mean, and I realize Lester could be your answer, but aside from Lester, is there an answer?
Actually, my answer is that neither Jones nor Wheeler were dealing with old rules. They were dealing with new rules. So I would submit that they don't actually reach the question of what happens to new rules. That wasn't before them. The question was not before the court to determine whether old rules and new rules should be treated differently under the savings clause. They were dealing with
Doesn't Jones say that specifically? Maybe I'm wrong.
Yes, no, Jones does say specifically new rules, but they don't analyze the question of whether there's a distinction between how you treat a new rule and an old rule, because they were dealing with a new rule of substantive law. They were dealing with those Teague exceptions and how to apply them. And I don't know of another case that deals with what is clearly the application of an old rule. I couldn't even name another situation where an old rule is clarified by the Supreme Court that leads to widespread reversal of settled substantive law. It just hasn't, I don't think that it's come up before. I don't know where it's come up before, and I didn't find any instances. And so I don't think that the courts were dealing with that. And in fact, I think in Han v. Mosley, when they reiterate the Jones test, they take out that new rule language. They just talk about the change in law. And so I would actually submit that there hasn't been a holding on this point because it has not come up. And and I would also clarify that I think that this rule would apply equally to Jones. It's not that sentencings would be treated differently than issues of the validity of the conviction. I think that if the validity of the conviction was reversed based upon a clarification of an old rule, that the test would be the same, that it is deemed retroactive at the moment it is deemed an old rule. But I will reiterate what Ms. Lorish said. I think that if the court is concerned about it, the solution also could just be the same approach that was taken in Young versus Antonelli, which is that you rule today that it is deemed retroactive and order further proceedings in accordance with that, which might is actually probably the simplest approach to take going forward. But if you have no further questions, I believe that is all I have to offer as well.
I don't see any other questions from our colleagues. Thank you, Ms. Blockhurst. So, Ms. Barber, we'll be glad to hear from you.
Thank you, Your Honor. And may it please the court, Katie Barber as amicus. The district court correctly dismissed Mr. Ham's petition for lack of jurisdiction, and this court should affirm. This case is about the limited last resort that Congress provides to certain prisoners who have already been convicted and failed to obtain other post-conviction relief. The Savings Clause provides one final narrow, highly restricted avenue for a prisoner to challenge her sentence through yet another habeas petition after she has been convicted, lost on one or more appeals, and lost on one or more 2255 motions. This court held in Jones and then also in Wheeler that the Savings Clause is extremely narrow and restricted to the most exceptional of circumstances. And rightfully so, because a prisoner who is invoking the Savings Clause has already had multiple opportunities to challenge her sentence. And so to get through the Savings Clause door, this court requires that prisoner to point to a dramatic change in the law. And specifically, it requires that prisoner to identify a new substantive rule of statutory interpretation that has been held to apply retroactively on collateral review. Now, it's correct that Wheeler is...
So let me ask you as a starting point, do you view the Fourth Circuit's decision in Hall to be a substantive law decision, and did it change the settled law of the circuit?
I do not view it that way, Your Honor. I think that, first of all, Hall was an unpublished per curiam panel decision that did not speak to overruling any binding precedent that predated Mathis. So I think it's hard to see how that's a change in this circuit's precedent. I also think that Hall is very different from what happened
let me ask you, at the time that Mr. Ham was convicted and sentenced, the district court relied on the cases that were outstanding at that time, whether they were other district court opinions or unpublished court of appeals opinions, that were all unanimous that the South Carolina burglary did qualify as a crime of violence. So that would appear to be settled law at the time of his sentencing, and Hall changed that. Are you relying on the fact that none of those were published opinions?
Well, I think there is some significance to that, Your Honor. But I think the more important point is that the settled law at the time that we're talking about was the Supreme Court settled law. So I think part of the problem with the discussion we're having is kind of conflating this court's precedents with the Supreme Court's precedents. And again, I think this is where it's different than what happened in Simmons. So Simmons and the way that it interpreted Supreme Court precedent in Carachuri was a procedural rule on a different issue. It was about how to determine what qualifies as an aggravated felony. This court in Simmons, in the en banc opinion, took the reasoning, the rationale of Carachuri to create a new substantive rule and overrule this court's prior precedent on what qualified as an offense punishable by more than 1 year of conviction. And what this court said in Miller, it described how that process was one of taking the Supreme Court's procedural rule, which Miller said did not overrule anything in this circuit, did not abrogate anything in this circuit, but using its rationale, this court underwent this process of statutory interpretation in Simmons, where it looked at what the term offense punishable by more than 1 year meant, and it redefined what that term meant and narrowed that term so that it applied to a smaller class of persons than that statute had originally applied to. And that is why Simmons was a new substantive rule, and it was a new substantive rule that changed this court's precedent. I think that's very different than what happened with Mathis and with Hall. Mathis is about the Supreme Court's precedent on a procedural matter, how courts just determine culpability rather than who is culpable in the first instance under a statute. And then in applying Mathis directly, this court came out differently in how it was viewing third-degree burglary. But I think that's a different situation. This court didn't in Hall then interpret the terms of a statute such that statute's terms were narrowed. Instead, Hall just simply applied the correct categorical approach, which, as the Supreme Court has said over and over again, is a procedural matter. It's, again, a matter of how courts look at criminal statutes as a general matter, rather than how one particular term in a specific criminal statute is defined. So I think that those are different situations, and I think that the key inquiry under Wheeler is the same settled law that made the prisoner's sentence legal. Did that same aforementioned settled law, is what Wheeler says, did that aforementioned settled law then change in a way that was then held to apply retroactively on appeal? By its terms, Wheeler only is satisfied by a new substantive rule, because only a new substantive rule can redefine the terms of a statute, narrow its scope, and only a new substantive rule will separately be held to apply retroactively on appeal. An old and especially...
So, Ms. Barber, so we could, in your view, resolve this case without determining whether Mathis was retroactive for purposes of prong 2 if there's no change in settled substantive law, correct?
That is correct, Your Honor. I think that, again, this court has said that prong 2 really has 2 elements to it, and so you need both the substantive, this change in settled substantive law, and the separate determination of the law being held to apply retroactively on collateral review. And I think that that also goes to a point that my colleagues were making about that, suggesting that this court could just do what the court did in Young v. Antonelli. And I think that Young is also a different situation than this case, because Young was about, okay, we have a new substantive rule, but it's only been applied to a statute. Can it be extended to the sentencing guidelines? And the district court couldn't do that on its own, but this court could do it. And I think that's a very different proposition than what we're talking about here. I also think that Young really reflects that Wheeler is only satisfied by a new substantive rule because, again, Burrage, which was at issue in Young, was similar to Simmons, similar to Bailey or to Chambers, to these cases where the court is undergoing this interpretive definitional exercise of looking at a term in a statute and deciding what it means. And that is just not what Mathis did. Mathis did not look at the terms of any one particular statute and redefine them. Mathis talked as a general matter about how courts read statutes in general.
Counsel, let me follow up and see if I'm understanding something about what you're saying. It sounds like it's your position that the law that existed at the time Mr. Ham was sentenced that made this made his South Carolina third-degree burglary a sufficient predicate offense. I mean, I think we all acknowledge that was the settled law, at least of this circuit at the time. And is it your position that there hasn't been a case that said that is no longer the situation with respect to that statute? And because I think I thought I heard you suggest that perhaps because Hall was unpublished. And if so, I mean, I just want to understand that first of all. I mean, if we had a decision that said, Kirksey, whatever the prior cases were, no longer apply. Mathis has come out and clarified things. We now see the light. It's a categorical approach, not a modified categorical approach. That's not an adequate predicate offense. If we had that in our circuit of precedent right now, would we satisfy Wheeler?
No, I don't think you would, Your Honor, because I think, again, the relevant inquiry in this case is what did Mathis do? And again, I think a good comparator is to what happens in Simmons, because Simmons was clearly this change in this court's own precedent. In contrast here, we're not talking about an area where the Supreme Court hasn't spoken on an issue, where this court has its own kind of body of precedent on a question. We're talking about ACCA precedent, which is something that the Supreme Court speaks to almost every term and clarifies or tweaks almost every term. And it cannot be that every time the Supreme Court does that, every time it makes the slightest adjustment in its law, that it throws wide open the doors of the Savings Clause. We know that the Savings Clause is meant to be far more restricted than that. And that's the balance that this court struck in articulating its test in Wheeler, is really balancing, the need on the one hand for the justice system to have finality, for a conviction to terminate at some point, balanced against the need to provide recourse in the truly exceptional cases that merit it. And I think that the court struck that reasonable balance by instituting this new substantive rule requirement, under which not every change in the law, not every slight adjustment or tweaking of precedent qualifies under Wheeler. It has to be something really dramatic and foundational. And we've seen what those cases are like, again, in Bailey and Simmons, Chambers, Burrage. These cases are all very different than what Mathis did, because Mathis is all about procedure. Mathis was dictated by existing long-standing precedents that the court had repeated for decades. And it did not narrow the scope of any one statute or interpret its terms. I just also want to note that I think it's important to see how this court's test is different from those of some other courts. I think in other courts, it is sufficient if it were just this court's own precedent that foreclosed a party's argument. But again, I think Wheeler sets a higher standard, says it has to be the same law that made the sentence legal has now changed. It's not merely enough that within this circuit, Mr. Ham couldn't make this argument. It has to be something more significant than that. And so I just think that, you know, this court's test needs to be looked at on its own terms, and those terms clearly require a new substantive rule, and Mathis is not that rule. So unless there are further questions from the panel, I will cede the rest of my time.
Hearing no other questions, thank you, Ms. Barber. Ms. Loris, you have some time in rebuttal.
Thank you, Your Honor. So starting where the amicus left off, I want to point out that the Wheeler test does not require that an intervening decision change Supreme Court law. It specifically requires a change in the settled law of this circuit. And Mathis did precisely that. Mathis and Hall are substantive in their nature because they narrowed the statutory term burglary in the Armed Career Criminal Act. What counts as a burglary has been narrowed, and that is a substantive change that applies directly to Mr. Ham. And I want to push back on the amicus's suggestion that this is a doors wide open situation. It clearly is not. It's a very small number of instances where this court has said an intervening Supreme Court decision has required us to change how we've previously interpreted a word in a statute. Here, this court did that in Hall. It did it for the same Virginia multi-locational burglary offense in Cass-and-Dent-Lewis that Mathis required changing prior precedent of this circuit. And for that reason, it is a restrictive test. It doesn't happen that often. And I would also note that the fourth prong of the Wheeler test always exists to prevent a floodgates problem that the amicus suggests could occur. The error we're talking about in these cases has to be sufficiently grave to be a fundamental defect. So the number of times where this court says an intervening Supreme Court decision has changed our precedent, and it's also a fundamental defect, it's a very small number of times. So the suggestion that this is going to be a wide-reaching situation is unfounded. As Ms. Bockhorst noted, it's a very small number of cases that fall into the situation that Mathis occupies, where it is based on prior precedent, yet it clearly changed the settled substantive law. And I did want to respond to the question that you asked of Ms. Bockhorst, Judge Quattlebaum, with respect to what the language about deeming indicates in the Wheeler prong that suggests that does the fact that a decision has to have been deemed retroactive somehow suggest that it must be new. And I don't think that that's what the phrase deemed requires there. I think a better definition would just be recognized. And I think that we know that because, as you brought up, Judge Quattlebaum, the Lester versus Flournoy decision found that Chambers was a decision that had applied retroactively, and it had changed the settled substantive law, even though the Chambers case was merely applying prior precedent the Supreme Court set out in Begay. Chambers didn't overturn a prior decision, it just applied Begay. And when this court found that changed the settled substantive law, it already answered the question here.
It kind of did. I mean, you know, the result, it said it met the Wheeler test, but the issue wasn't contested, and there really wasn't any analysis of prong 2 in Lester. I mean, I agree with you on the outcome. I think, you know, that was really a prong 4 test, not a prong 2 test case. But I get your point. I mean, they didn't stop it there as the court could have, perhaps, if that was the intent. So I understand your point, but you may be giving it a slightly broad rating, but I understand where you're saying.
Thank you. I want to, with my remaining time, also address the suggestion of the amicus that we should be looking to the Jones test at all. In the Farkas decision that this court issued, it explained that there's 2 different tests that apply. And the test that applies for a challenge to an erroneous sentence is clearly the Wheeler test. So the Jones decision and whatever it may have held is irrelevant in this context. We only look to the Wheeler test. And so I think to the extent that the Wheeler test has created a broader conception of 2241, that's the test that's binding on this court. This is not the case that's going to expand Wheeler. Wheeler already exists. It's the law. It doesn't require a new decision. It only requires a decision that changed the settled substantive law. And that's precisely what happened for Mr. Ham. Mr. Ham is not someone who slept on his rights, as Ms. Barber may have suggested. He did appeal. This court accepted an amicus brief in his appeal because there was no meritorious issue. It's not as if he didn't try to take advantage of the rights afforded to him, but the settled law of this circuit foreclosed that opportunity up until Mathis changed the law, and this court acknowledged as much in the Hall decision. Thank you very much.
Thank you, Ms. Lorsch, and to all counsel. You wrote good briefs and provided excellent arguments on a somewhat complicated, quasi-esoteric topic, so we'll take that under advisement. Ms. Barber, I do note that you're court appointed, and the court wants to express its special appreciation to you for taking on the task in this case. So with that, the court's going to take a very short recess, and then we'll be back for our next case on the docket.
This court will take a brief recess. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
We are ready to hear argument on our next case, 1924-52, Shepard versus the Visitors of Virginia State University. Mr. Crowley, we'll hear from you.
Thank you, Your Honor. May it please the court, my name is Scott Crowley, and I represent the appellant, the plaintiff below, Malcolm Shepard. This appeal concerns two issues of law. The first is whether Shepard stated a claim for sex discrimination in an educational program under Title IX of the Education Amendments of 1972, when he was adjudicated for assault against a former girlfriend at Virginia State University in Petersburg, Virginia, while the university took no action against the former girlfriend, who I identified in my brief as Student A, for larceny arising out of the same incident. The second issue is whether Mr. Shepard raised a property interest in Virginia State University's Student Code of Conduct governing disciplinary actions as a predicate for his claim of violation of his due process rights under the 14th Amendment, when the administrator of the disciplinary program, named Henry DeBose, suspended Mr. Shepard haphazardly without an opportunity to be heard. Focusing first on my Title IX claim, he proceeds under the selective enforcement theory first articulated by the Second Circuit in the case of Youssef versus Vassar College. Mr. Shepard claims that since the charges against him arose from the same general altercation, which is a theft of personal property, which led to a confrontation and then shoving, the circumstances surrounding Mr. Shepard and Student A were sufficiently similar that the fact that Virginia State University took disciplinary action only against Mr. Shepard and not against Student A or Student B stated.
So Mr. Crowley, if I could interrupt you right there.
Please.
Whether they were or not similar is really not my question right now, but we've not specifically held that for a Title IX case you have to have a comparator.
No.
But it sounds like your position acknowledges that that's a requirement and you think it's been sufficiently pled. Am I understanding your position correctly?
I don't want to sound vague, but I think I have enough to plead a comparator case. But I will say that there are other circuits, including 4 circuits, that have ruled on this precise issue since we briefed this issue. And I have the citations where they've said enough of the theories under Youssef. All we need to do, we need to go back to original principles and look at the text of Title IX, which says, is there discrimination based on sex in an educational program? And you just need, and then you need to look at the analogous Title VII of the Civil Rights Act. That statute, of course, requires that discrimination be only a motivating factor. And so whether we look at it as strict comparator analysis or whether we look at it more broadly into whether there's enough facts in here to infer at this stage of the pleadings, infer a cause of action.
Mr. Crowley, did you say that there are several cases that you believe are in your favor that have come out since you filed your brief?
Right.
Okay, so have you submitted a 28J letter to give the court an opportunity to look at those, as well as to give opposing counsel an opportunity to look at those?
No, and I'll just be honest, I've come across these cases last night in preparing for this argument.
Okay.
I'd be happy to supplement, and I understand it's not unusual, but some of these cases have come out just, in fall of 2020, after we briefed it. And I've got cases from the 3rd, the 7th, the 8th, and the 9th circuits that have all followed the 7th Circuit in Doe versus Purdue University, which says, we don't need to be bound by these strict theories of life.
Well, let me ask you a different question. How can you say that Student A was treated favorably when she was found responsible for the theft?
She was treated favorably in the enforcement in that she was only adjudicated for the theft after Mr. Shepard approached the Department of Education Office of Civil Rights and filed a complaint against Virginia State University, because until that time.
So you're speculating that nothing was going to happen to student A? Otherwise, we would have to speculate that, wouldn't we?
I wouldn't use the word speculate. I would use the term that I've alleged enough facts to infer a cause of action that gets me over the edge for a 12B6 motion under Iqbal and Twombly. Now, whether those facts can be borne out in discovery, I don't know, because I've had no discovery, but I think I'm entitled to an inference that when Mr. Shepard is receives a notice of pre-hearing disciplinary action the day after the altercation on October 25th of 2016, and then with less than a week he's adjudicated, and it's not until 4 months later that the university sends any sort of notice to student A, and only after the Office of Civil Rights from the Education Department contacts VSU and says there's been this complaint, and then 4 days later they hurry up and file papers to get student A. I think that is beyond speculation. Now, those facts may not bear out discovery, but I think I'm entitled to
You're saying that's a reasonable inference based on the timeline of events?
That's a better way of saying what I'm trying to say. Yes.
But the university had proceeded against student B much earlier than that. Isn't that correct?
Let me get my timeline. The university sent a pre-hearing notice to student B on January 11th, which was 3 months after my client was adjudicated and already left the university. But that was before the Office of Civil Rights got involved. So you're right, that the student B was subjected to discipline, but not till sometime later. Which
well, let me take you back sort of to the threshold question, if I could. I understand that there are some other circuits that have looked at these types of Title IX claims under a more generic Twombly analysis. But in this case, as I understand it, you have pled and you have argued until today solely under a USEF proceeding based on selective enforcement. So what entitles you to come in at oral argument and seek to change the gravitas of your pleading?
Well, my argument has always been that if you look at the circumstances in total, I have alleged on behalf of Mr. Shepard a prima facie case of sex discrimination. So yes, I've chosen to call it selective enforcement under USEF. But the fact of the matter that since all of these charges, the theft and the assault, arose from the same incident involving the same characters, the same decision makers, the same code of conduct. The fact that one was treated more leniently than the other gives me an inference of sex discrimination. Now, it could be real.
Well, tell us why you say he was treated more leniently, because as I understand the pleadings and the briefing, there isn't any contest as to your client being guilty of the charges against him, nor is there any question as to students, at least student A, being guilty of the charges against her, nor of the penalty imposed against student A. That the only difference between the parties is the timing of when the discipline was imposed. Is there anything else that you say reflects a difference between the two?
Well, the timing, but I also assert, I'm going to take this timing one step further and assert that had Mr. Shepard never complained to the Office of Civil Rights, the university would have never enforced any disciplinary action against student A. And you're right, I'm not saying that the outcome against Mr. Shepard was wrong or unfair, but it's essentially like two basketball teams playing and the refs only calling fouls against one team. Now, those fouls may be legitimate fouls, but if they're only going to call them against one team, at some point you need to say, why is the university calling fouls at all? Maybe all of this should be left up to the court authorities and not impose sanctions of suspension. And that's really where I'm going in this case.
But how did they not call a foul against I think it's student A, when she was found responsible for the theft?
But they were only shamed into that because he complained.
I mean, it's
right.
Well, just to go with your analogy, you said that there were no fouls called against one team, when in fact there was. That student was found responsible. Now, it might have been, for a football analogy, a late flag thrown, but the flag was thrown. So how does that fit into your argument?
It was thrown only after an appeal to a much higher authority that could have done some harm against.
So that goes back to your reasonable inference, our reasonable inference discussion from earlier.
Right.
Okay, go ahead.
With the court's permission, I think I may move on to the due process issue. Under Board of Regents versus Ross, the Supreme Court said that property interests, we know they're not created by the Constitution, but they can be created and their dimensions defined by existing rules or understandings that stem from an independent source. And this goes on, such as state law, but it doesn't have to be state law. The fact that VSU, like many public institutions, publishes precise procedures to be invoked in the situation of student discipline shows that the student has a property interest in the enforcement, in the utilization of those procedures, so that the university can't simply jettison those and say, we're going to suspend the student without a hearing, without even hearing what the student has to say. And that's what happened.
So,
well, counsel, am I correct that the district court addressed this issue in the alternative and found on the merits that there was no property interest, but also that qualified immunity applied?
Yes, yes. And I obviously disagree with both points, because there has to be some veneer of property interest for due process. When the university gives these rights, they accept tuition from the student. It's a public university. They have to, it doesn't mean they have to provide all the niceties of due process that is found in a court of law, but they have to at least hear the student out. And that didn't happen here.
Well, even if we assume that the district court was wrong on the merits, if qualified immunity applies, that would still defeat your client's claim.
It would.
And as I read your brief on page 16, you say it's an open question whether students enjoy a property interest in higher education that affords due process protection. And it would seem to me with that you in effect have conceded there is no clearly established law which would require the application of qualified immunity.
I think what I would revise my statement to say there may not have been a state law that guarantees a student a right to continuing education, but there are these procedures in place that guarantee the students due process before they're disciplined. And
if you, Mr. Crowley, or can you, I mean, if there's no Supreme Court authority saying what you just said, that these policies create a property interest, and there's no Fourth Circuit law saying that. Just on that basis, well, I understand your argument, but given the fact that we don't have anything, at any appellate court, is there any way it can be clearly established?
My time's running out. Can I just answer that question?
Yes, go right ahead.
Thank you. There are so many cases out there of this sort that where courts acknowledge some veneer of due process has to be given before a student can be either expelled or suspended. Just Board of Regents versus Roth alone, that comes from 1972. The idea that an administrator who administers these policies with these guarantees in the student code of conduct would somehow think that he could kick a student out without even asking the student what happened or explain why he's doing it. I mean, anyone would understand that at this point. It's almost like a police officer questioning a suspect without giving Miranda rights. I mean, it's just known. Now, 6 decades ago, it wasn't known, but it's been known since the 70s, and it's the same here. I mean, it's VSU that provided these policies. All we're doing is saying, if your policies say you can't suspend a student without telling him or her why you're doing it and giving that person an opportunity to be heard, then that's a violation of due process.
All right. Thank you very much. Mr. Crowley, you have some time left on rebuttal.
Thank you.
And we'll now hear from Ms. Kayla.
Good afternoon, Your Honors, and may it please the court, Michelle Callan for appellees. The district court properly dismissed Mr. Shepard's complaint against each of the 2 defendants. As to VSU, Mr. Shepard's Title IX claim fails because he acknowledges that USIF's selective enforcement framework applies, but Mr. Shepard fails to point to any remotely similar comparator of a different gender. Now, I'd like to add another relevant date in terms of the timeline of what occurred in this case. Your Honors, less than a month after the event at issue here, on December 17th, 2019, the Office of Judicial Affairs at VSU gave notice to both Students A and Student B to let them know to email OJA. Yes, Your Honor. I think I heard a false judicial question.
Yeah, there's a false flag there.
So I think it's worth noting, Your Honors, that December 17th is also a relevant date here, and that plainly comes well before any complaint to federal authorities. I think any theory that this case is premised and that the disciplinary proceedings somehow followed from Mr. Shepard's complaint to the Department of Education is highly speculative and is undercut by the timeline in this case too. As my friend on the other side of
And what was it that you said happened? What was the date you wanted to add? I'm sorry, I missed it.
December 17th, December 17th, 2016, which is less than a month after the incident here where Mr. Shepard pushed Student A. So that just goes to show
that date is what you've just recited to us. That's in the record that we have.
Yes, Your Honor.
Let me ask you, as I understand Mr. Crowley's argument, he says that notwithstanding pleading and arguing under USEF with a selective enforcement theory, that we really ought to look at the Title IX case more under a Twombly analysis instead of a USEF analysis. What's your response to that?
I think twofold, Your Honor. So he himself only briefs the selective enforcement theory, and I think it's worth noting an event. This court issued an unpublished decision this past October, where this court recognized the USEF standard as well. That's the Doe 2 by and through Doe 1 v. Fairfax County. It's 2020 Westlaw 6158091. It's an unpublished decision, but it is one in which the USEF standard was referenced by this court. But even applying the plain Iqbal Twombly pleading standard, the complaint here plainly fails that as well. I mean, the complaint does little more than saying, because they are female and because I am male, I was treated differently. That's just insufficient even under Iqbal Twombly to state a Title IX claim. And I think that's highlighted, that the insufficiency of this complaint is highlighted by one of the cases that my friend on the other side relies on. So in his brief, he relies on the Doe v. Amherst College case out of the District of Massachusetts. And there were allegations that that the college at issue encouraged the female student to file a complaint against the male student when there were sexual misconduct allegations. And by contrast, the university, when the shoe was on the other foot and it was the male who was alleging sexual misconduct against the female, the plaintiff there alleged that the university did not encourage the male victim to file a complaint. And so the differential treatment by the university of the male versus the female students there was the allegations in the complaint that there was a difference in treatment. Here, the only difference is a pace in the proceedings of the disciplinary process. Student A was disciplined and faced consequences to larceny in the disciplinary process. So the only difference is simply the pace, and that's insufficient to show differential treatment, but it's certainly insufficient to show that the reason for the differential treatment was based off sex, especially when Mr. Shepherd committed a violent offense under the student code, and student A committed a property offense. He simply took a cell phone charger and some clothing items. So that plainly explains the difference in the pace of the disciplinary proceedings. I think it bears noting, unless the court has additional questions on the Title IX piece of the case, we think that this case plainly fails under both the selective enforcement theory and a plain Iqbal Twombly pleading standard. Moving on to Mr. DuBose, those claims fail on the merits, but at the very least, Mr. DuBose is entitled to qualified immunity. On the due process claim, Mr. Shepherd himself admits that this court has not adopted his theory of a property interest. And on his equal protection claim, Mr. Shepherd fails to cite any case, let alone one from this court, the Supreme Court of the United States, or the Supreme Court of Virginia, adopting his novel same incident theory. This court on multiple occasions has emphasized the deference that it accords to academic decision-making, particularly in the disciplinary process. That deference is appropriate here, and the district court's decision should be affirmed. Unless the court has any more questions, I'll yield the remainder of my time.
Seeing no hands up, I'll thank you, Ms. Callan, for your argument, and we'll go back to Mr. Crowley. He's got rebuttal time.
Thank you, Your Honor. I just want to, Ms. Callan said something to the effect of that our side was alleging just because Mr. Shepherd is male and student A is female, there must be discrimination. And I mean, that's simply not the case. We're looking at the totality of the circumstances. The fact that it occurred at roughly the same time, same incident, actually, in that the university was so prompt in getting notice of pre-hearing to Mr. Shepherd, and then did nothing against student A or student B for some time, sent out a notice of pre-hearing against student B on December 17th, about 6 or 7 weeks after the incident, which is ironic because student B was not nearly as culpable as student A.
That notice went to both students, didn't it? Students A and B.
No, our fax it only went out to A. I mean, excuse me, B.
What's your JA site for that? If I can find it, if you don't have it quickly. Maybe. Mr. Crowley, that's all right. I can find it in the record.
Okay. I think in my paragraph, I need to correct what I said. Paragraph 37 of the amended complaint says it's sent on December 17th. It sent her an email, not a pre-hearing notice, but an email saying, please contact our office. That email was ignored. And then on March 20th of 2017.
Okay, so
that-
you're saying that the basis for you saying that the December 17th email only went to student B is what's alleged in your complaint?
Correct. We alleged in the complaint that an email was sent
Right.
to student A saying contact the office, not what it should have said, which is this is a pre-hearing notice.
Okay, so you agree it did go to student A on December 17th?
An email went out saying please
Right,
contact.
right, saying
Yeah.
please contact the office about your, about the conduct or whatever.
Yeah, that's
Okay,
accurate. And I apologize for my misunderstanding.
okay, thanks.
But student A ignored that notice, and the university took no action to follow up or impose any discipline until after Mr. Shepard went to the Office of Civil Rights. He actually went January 23rd, but the university didn't get notice of that complaint until March 16th of 2017. And then on March 20th, they issued the pre-hearing notice against student A. And then April 7th, I believe, of 17 is when they had the hearing, the adjudicatory hearing for student A, and found you responsible for theft. Unless there are any questions, that's my presentation.
All right, thank you very much. We appreciate the argument of both counsel, which you will be taking under advisement. So we'll take about a 30-second stretch break as the clerk brings the next set of lawyers in for our next case.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
We're now ready to hear argument in our next case, 19-1674, which is Combi Incorporated versus Dr. August Wolf, and various initials and words in German I can't pronounce, so I won't try. So, Mr. Panko, we'll hear from you first.
Good afternoon, Your Honors, and may it please the court. Ross Panko from Errant Fox on behalf of the appellant, the Dr. Wolf Company. The district court's decision should be reversed because it was clear error for the court to find that Dr. Wolf's trademark, Vagisan, presents a likelihood of confusion with Combs' trademark, Vagisil. Specifically, the district court erred by misapplying 5 of the likelihood of confusion factors, all of which should have been weighed in Dr. Wolf's favor. The most important of those factors were the first 2, the strength of the plaintiff's trademark, which courts say is the paramount factor in the likelihood of confusion analysis, and number 2, the similarity of the parties' trademarks. The court's incorrect analysis of those 2 factors caused it to tip the overall balance of the confusion assessment in Combs' favor and to incorrectly rule for Combs. What the district court should have done is what the Trademark Trial and Appeal Board did in 2017 before this case was appealed to the district court. The TTAB examined these same likelihood of confusion factors and reached the opposite decision and found no likelihood of confusion. The TTAB reached that decision by correctly applying the crowded field doctrine, which is critical to the strength of the mark factor and also to the similarity of the marks factor. What the crowded field doctrine holds is that when you have a mark like Vagisil, which includes a merely descriptive element, vagi, and which has been coexisting for decades with a multitude of competitors who likewise use that same prefix for their trademarks, then what you have as a matter of law is a crowded field of similar trademarks in which each member of that field gets only a very narrow scope of protection against competitors who also use the vagi prefix. In addition, what the law says is that when there is a very large number of third-party uses, which is the case here, the plaintiff's trademark has to be considered both conceptually and commercially weak, and that overall, the strength of the plaintiff's mark factor has to be weighed in the defendant's favor. And so the district court made a clear error here in analyzing the strength of the mark factor because it conducted the first part of that analysis correctly. It held that Vagisil was conceptually weak because of the widespread third-party use of the prefix vagi, but then it went on to make a clear error by holding that those third-party vagi trademarks were irrelevant to Vagisil's commercial strength, and that the commercial strength of Vagisil trumped its conceptual weakness. That conclusion was a clear error because what the law says is that when the marketplace is this crowded, when the amount of third-party use is powerful on its face, it means that the plaintiff's mark is both conceptually and commercially weak. And here the third—
Counsel, if I'm remembering the record correctly, a number of these third-party uses either had no sales or the sales were so insignificant that they were de minimis. It seems like I remember for some number of these third-party products, the only sales were where either you or other counsel for your client were the ones who bought them. So it would appear that that Combi's product just has a very dominant market position, almost exclusive.
Comb does have high sales of the product Vagisil. That's correct, Your Honor. But that's not the end of the analysis. And with regard to, it's correct that some of the third parties did not yet have substantial sales. To provide the overall picture of the third-party use, Your Honor, there were a total of 66 third-party vagi trademarks that have either been registered or used over the lifespan of Vagisil. And there were also 17 uses of vagi prefix marks by third parties and 11 live registrations at the PTO. And so with regard to that group that you mentioned, there were 14 marks that the district court incorrectly considered irrelevant because they didn't have substantial sales. But that conclusion is wrong as a matter of law because the relevant issue for third-party marks is not the amount of individual sales by each particular third party. Instead, what's relevant is the overall cumulative impact that a large number of third-party marks has on the strength of the plaintiff's mark over time. And this is precisely what the Fourth Circuit held in Variety Stores versus Walmart, in Care First, and in Valador. For example, in Variety versus Walmart, this court reversed the district court's finding that the plaintiff's mark was strong and held that the extensive evidence of third-party use meant that the plaintiff's mark was both conceptually and commercially weak. And the Variety Court's reasoning for that decision was that one of the key metrics of commercial strength is the degree of exclusivity associated with the plaintiff's mark. And so when you have a landscape that's flooded with third-party uses, as this landscape has been over time, that degree of exclusivity is extremely low. And the Variety—
But counsel, just these factors, and I may have it wrong, I know this is an area where you probably have a lot more expertise, but it looks like these are factors that the district court or whoever the fact finder is here, the district court weighs. And here the district court looked at all the factors and looked, you know, beyond just the numbers into the quality of the, you know, of the alternative sales, looked at a survey that was in evidence without objection. And, you know, I certainly appreciate your position, but as I read those factors, it did not look like they were so cut and dried that this would amount to an error of law. And it looks like what you're arguing is you think he got it wrong in his weighing analysis, and maybe he did, but why, how does this establish clear error?
It's clear error, Your Honor, because the reasoning of the district court's decision showed that the court didn't follow Fourth Circuit authority on the issue, including those cases I just mentioned, including variety stores versus Walmart, which is that courts, when they analyze the impact of third-party marks, they don't dissect each individual mark to examine the particular sales. It's the cumulative impact over time that is relevant to the strength inquiry. And so here, Your Honor, the district court made a clear error by failing to follow that Fourth Circuit authority. But it wasn't just those 14 marks.
Didn't the surveys before the court take all of that into account?
Well, there were two surveys, Your Honor. One was a FAME survey that goes to the strength of the mark factor, and one was a confusion survey. Both of those surveys should have been given no weight because they were defective. They both used. Main problem with both of them was that they used an implausible and defective control. So
A what? An implausible?
Control. So both.
Right. And you're saying that you said Vagisox that's the implausible control?
That's right, Your Honor. The problem with Vagisox, which was the control in the FAME survey, and with Vagipur in the confusion survey, was that they, in addition to being implausible, they weren't close enough to the mark being tested, Vagisil, to provide.
And weren't there? But the court heard all of that and heard from experts on both sides. So how don't we owe the district court deference in that regard? When I mean, your client didn't conduct surveys.
That's true, Your Honor, and there is no obligation for a defendant to conduct a survey. There's no, inference.
I understand that.
It's true the court does get some discretion, and it's a clear error standard. But here, what the case law shows is that the court didn't follow the law with regard to survey science on these two surveys.
Did your client submit evidence of marks, other marks?
Third-party marks, Your Honor?
Yes.
Yes, Your Honor. These are the 66 third-party Vagi trademarks I mentioned earlier, as well as the.
Well, I think so. All right, go ahead.
So just to sort of big picture, the relevance of these third-party marks, Your Honor, is that it shows that consumers have become conditioned to distinguishing over time between multiple Vagi prefix marks in the marketplace. Two very good examples of that can be found in CVS, Rite Aid, Target, and Walmart. And that's the Vagicaine product and the Vagistat product. So if a consumer walks into any of those four stores now, you would see Vagisil and Vagicaine side by side on store shelves. The district court incorrectly disregarded Vagicaine because it was a private label product. But that was an error, Your Honor, because the cases the court cited were trade dress infringement cases. And this isn't a trade dress infringement case. And in fact, the trade dress cases that the court cited actually support Wolf because they show that when consumers are distinguishing between these marks, what they look at is the words on the package. They look at Vagicaine or they look at Vagistat. And speaking of Vagistat, the court incorrectly found that mark was irrelevant because it was purchased by Comb one year before the trial in this case. But that was an error also, Your Honor, because Vagistat coexisted in the same stores as Vagisil for 34 years. And so Comb's recent purchase of it doesn't erase from the public mind the fact that Vagistat coexisted in the same stores with Vagisil for years without confusion. And so there's no reason why Vagisan couldn't likewise coexist in those same stores. The next significant error that the court made, Your Honors, was with regard to the similarity of the marks factor. Here, the court made a clear error because it held that the descriptive prefix "vagi" was the dominant portion of the party's marks, and thus it focused its comparison on that element. But that approach was a clear error because it is exactly the opposite of what the law requires. What the law says is that when you have two marks that share a descriptive component like the prefix "vagi," the focus of the analysis shifts to the non-common components, or in this case, the suffixes "san" and "sil." For example, this is what the Federal Circuit held in Swatch versus Berger, which involved the marks swatch and iWatch, and found them not confusingly similar because the generic root watch in those marks was not sufficient to make the marks similar. And the same was true in a litany of other cases cited in our briefs, including the water pit case, which involved SinuSense versus SinuCleanse for sinus products. And another case was the Land-O-Nod case, chiromatic versus chiropractic. Again, in all of those cases, the court correctly focused the analysis on the suffix of the marks. And because of the widespread third-party use of the generic prefix, the court correctly found that the marks were dissimilar and that there was...
But counsel, once again, I mean, I think from our review of the record, certainly the district court acknowledged the similarity at the beginning of the marks, but it also discussed the differences. It didn't ignore them. It said the differences were only 2 of the 7 letters and pointed out that, you know, it was at the end. So again, maybe he should have, or the district court could have done differently, but it's not like it ignored. I guess my problem is you're suggesting that because he didn't find in your favor on that, it was wrong, when it looks like he's looking at the suffix part of the mark. He just gave it less weight than you argue it should have, which is what happens in, you know, trials all the time. You know, there's evidence and a fact finder looks at it, and one side it says, often says it should get this weight, and another says it should get different weight. But yeah, that's what fact finders do, and we're really not here to second guess that.
Well, the error that the court made, Your Honor, was a misapplication of the law, in the sense that the court said that the prefix "vagi" was the dominant element for the sake of comparing the two marks. That's contrary to what the law requires. What the law says is that when you have two marks with a generic or descriptive element, the analysis, the dominant element is the suffix. And so the court's reasoning suggests that the court misapplied the law by focusing on the generic prefix. The third likelihood of confusion factor that the court misapplied was the sophistication of the consuming public factor. And the court made an error here by finding that the factor was neutral, but this was a clear error because the record showed that a product of this type, a vaginal care product used for an intimate part of the body, is purchased with a high degree of care by consumers. And Combs' own witness in the TTAB proceeding acknowledged that fact, as did Wolf's witness. And so, and there are a number of cases involving personal care products, including tampons, lotions, and hair care products, that have held that consumers buy those products with a great deal of care, which lessens the risk of confusion. And the court should have followed those cases here. And so, in conclusion, Your Honors, the district court decision should be reversed because the court committed several clear errors in its analysis of the likelihood of confusion. Thank you, Your Honors.
Thank you, Mr. Panko. You've got some time on rebuttal. We'll now hear from, is it Ritu?
Yes, Your Honor. Yes, Your Honor.
All right. Well, Mr. Ritu, tell us what you have.
Thank you, Judge. Doug Ritu for the appellee Combe. May it please the court. Your Honors, this trademark appeal turns on the highly factually intensive issue of likelihood of confusion and can be decided just based upon the standard of review, which, after a full trial on the merits, is the clearly erroneous standard. We know under the clearly erroneous standard, if the district court's account of the evidence is plausible, the Court of Appeals may not reverse it even if the court would have weighed the evidence differently. Put another way, where there are two different permissible views of the evidence, the fact finder's choice between those two cannot be clearly erroneous. And in the Supreme Court Anderson case said it best when they said that the trial on the merits should be the main event rather than the tryout on the road. And this was the main event. It was a full trial before Judge Ellis with live testimony, with dueling experts, with 688 admitted exhibits, and with a thorough, complete, supported 52-page decision by Judge Ellis, finding that confusion is likely. Now, Wolf disagrees with Judge Ellis, but it cannot show that the court was wrong or that his fact findings, the court's fact findings, were unsupportable or implausible. Now, Wolf first takes issue with the analysis of the strength of the mark, the strength of the Vagisil mark. Now, as this court explained in Variety and in Grayson and elsewhere, the commercial strength of a mark turns on whether consumers associate the mark with a unique source. So to evaluate that, the Fourth Circuit looks at a number of factors: advertising expenditures, consumer studies, sales success, unsolicited media, attempts to plagiarize, length and exclusivity of use. The court looked at all of these thoroughly and based its finding that Vagisil is a strong mark based upon multiple forms of potent evidence. First, Vagisil was used for has been used for over 45 years. That's Joint Appendix 458. There's been over $1 billion of sales of Vagisil products since 1991 alone. Vagisil products, a number of them, have led numerous product categories as the product leader in terms of both sales and units. There was evidence that Vagisil has been advertised extensively for decades in virtually every media possible: TV, internet, radio, you name it. Comb has spent over $425 million since just 1993 advertising Vagisil. And importantly, the court noted Vagisil is consistently recognized in major publications and in popular culture. It's on the popular TV shows The Big Bang Theory, South Park. It even got the coup de grace of a trademark. It got its own skit on Saturday Night Live. It is a famous mark. To boot, the court also had an empirical survey conducted by Comb showing that over 85% of people recognize Vagisil. And this is significant because it wasn't just buyers of the product. It was men, women across the country, ages 18 or over 85% recognize Vagisil. You can't get much better than that. Now, Wolf can't challenge a lot of this evidence, so that it nitpicks at two things. It nitpicks at the third-party evidence and the weight given to the FAME survey. Turning to the third-party evidence, courts do look at third-party evidence to determine the strength of a mark. But as this court said in Care First and Grayson, they look to whether the use is extensive and they look at its frequency. And so necessarily, a court must look at the quality of the uses to determine if they've had the impact on the plaintiff's mark. You can't just take them at face value. And in fact, the court did that here. The court explained that if these third-party marks are not in use, or if they have meager sales and advertising, it's unlikely that consumers are familiar with the mark, and therefore it's unlikely to denigrate the source identifying power of the plaintiff's mark. This makes perfect sense. If there are marks that are out there that nobody knows about, how could that diminish the value of the plaintiff's mark? And in this day and age with the internet, people could find anything everywhere. There's, I think, 1.7 billion web pages out there, and a lot of uses that are irrelevant and don't touch consumers. In this case, for example, the court, and in the joint appendix at page 273 to 274, the court did a nice job laying out all the evidence. And as the court noted, the evidence was very meager. And it makes sense. There were marks like Vagitone, which had $346 of sales in 2018. There were 7 marks that a paralegal from Combs law firm went out and bought over the internet, but there's no evidence that anyone else has ever seen or bought those products. And so it stands to reason, how can these products make Vagisil any weaker when they're not found on the store shelves, when people don't buy them, when there's no evidence that people know about them? The mere existence of these marks cumulative or not, does not denigrate the strength of the mark, which is what we need to look at here. And as the court noted, those marks shed little light without more on consumer perceptions. They are in essence, and the court didn't say this, I'm saying this, they're in essence grains of sand on a beach. They're insignificant. And Wolf's argument also fails for two other reasons. First, the third-party marks that they rely upon did not share the similarities that Vagisil and Vagisan share. They did not have Vagi plus an S plus a vowel plus a consonant. They were different marks. Second, there were not many of them. There were evidence that were 66 registrations at some point in time, but the only evidence of use of these marks was 15 uses. And of those 15, the court noted 14 had extremely limited sales. 7 were purchased by the paralegal at Wolf's counsel's law firm, who went out over a period of 2 months to try to find everything he could under the sun. But what's most telling is there is testimony from Wolf's business person that she did not know, even though she had studied the market since 2011, she did not know of these marks until this case. If these marks had any significance, their main witness would have known about that. And that is at the joint appendix at 572 and 573. But even if we accept the evidence, it really does pale in comparison to the evidence in cases, including the Variety Store case. Variety Store is telling because that was a appeal of a summary judgment decision. So the court didn't necessarily embrace all of this third-party use. And in fact, there were 539 marks in that case, including businesses found by an investigator. And what the court said is, that's enough to raise an issue of fact. And the court sent it back to the trial court and noted that the fact finder could find that those third-party uses did not impact the plaintiff's mark. And that goes to a fundamental point. And that fundamental point is, this is an issue for the fact finder. And the fact finder here did an incredibly detailed job at looking at the evidence and weighing it. And certainly, it was not a mistake in the way it was done. Counsel also talked about the private label marks that appear in major retailers, CVS and Rite Aid, and notes that the case that the court relied upon, which is McNeil Nutraceuticals, a Third Circuit case, actually supports Wolf's position. It does not. In that case, the court noted, and it's an interesting fact, I didn't realize, that these private label brands have existed since 1883. And the court said, when you see these private label brands, people have become accustomed over the last century to know that if it's got the store's name on the brand, that it comes from the store. And the court specifically said, people are aware of what store they're in, and they're aware when they see a product with that store name of what it is, so therefore it's not likely to cause confusion. Judge Ellis said just that here. He said these third-party marks are not relevant because they all have the name brands on them. They have CVS, they have Rite Aid, they have Equate, they have Up and Up. And therefore, consumers are going to know, they're not going to perceive Vagicane as a trademark. They perceive the store brands as the trademark, as the court said to do in McNeil Nutraceuticals. And it's just a signal that this is the generic store version of the famous Vagisil product. This is supported empirically by the survey that Combe did. And that survey showed that nobody in that survey mentioned Vagicane. Nobody. They did, however, mention the Walmart private label brand Equate. And 1.7% of people did that. So it just shows the insignificance of that particular brand. Also, to that end, the court has noted that when we're dealing with experts, an appellate court should be, and I quote Hendricks, an appellate court should be especially reluctant to set aside a finding based upon a trial court's evaluation of conflicting expert testimony. And that's what we had here, conflicting testimony, although Combe had 2 surveys, Wolf had none. On the issue of Vagistat, that is a brand that Combe purchased in 2007. Importantly, there is testimony in the record from Combs' main witness, and this is at the joint appendix at 494, that Vagistat was purchased to enter into a new category that Combe had not been in before, a category that did not compete with Vagisil. And that category is the antifungal yeast infection category. Now, Judge Ellis, the court, decided that that was different enough that it didn't harm the value of the Vagisil mark, and Wolf disagrees. But again, that disagreement does not constitute clear error, especially given the fact that Wolf's own paralegal, who went into stores, testified that he did not see Vagistat next to Vagisil. It was separate, and it was next to Monistat, which is the competing product, and that is at the Joint Appendix at 241. Wolf also takes issue with the FAME survey. Again, the court looked at this in detail. They found that the Vagisox control was appropriate, and that was a perfectly sound decision because there was evidence elicited in cross-examination of Wolf's expert that the U.S. Patent and Trademark Office has registered Zox formative marks before. Beyond that, Wolf's expert conceded that Botox is a plausible name. That's at 445. Wolf's main corporate witness conceded that Vagisox itself, this control, and I quote, could be a plausible name for a vaginal product. That's at 574 in the record. And again, the 5.3% awareness rate for Vagisox showed that it did just what controls in this type of survey do. And there's testimony on that, and I refer to Joint Appendix at 294. But at the end of the day, where does this all go? This all goes to the issue of strength. And Wolf cannot show that it was clearly erroneous to find Vagisil strong because its own expert conceded 3 times that Vagisil is strong. Its expert said, and I quote, that Vagisil is well known however you define it. At another time, he said it is well known, quote, relative to other brands in this category. Then another time, he said Vagisil is well known in this category. And this is at the Joint Appendix at 443 and 444. With those admissions, with all the evidence, Wolf cannot show that the court clearly erred in finding Vagisil famous. Wolf also takes issue with the similarity between the marks. It is fundamental within this circuit and outside of this circuit that one cannot and should not dissect trademarks. They must be looked at in their wholes. Secondly, strong marks must be afforded a greater scope of protection so that less similarity is required. With that lens and those rules, the court did not err in its factual findings. And its factual findings were, first, compared as a whole, Vagisil and Vagisan are similar in sight and sound because they both have vagis, then a vowel, and then a consonant. That's at 297. The court also found that the minor differences between these marks, the final 2, vowel and consonant, was less pronounced because it was at the end of the mark. The court found, third, that the marks are perceived similar by the eye and the ear. Fourth, the court found that the meaning evoked by the marks is similar because both connote the vaginal area. This is all confirmed and supported by Combs' confusion survey, where Combs' expert used a very conservative control by showing people just the mark Vagisan. And people confuse that with Vagisil, not with any other vagi marks that Wolf contends are out there. Now, Wolf talks about the cases, certain cases, and we've already distinguished those on pages 40 to 42 of our brief. The court distinguished them on JA 229 to 230. But generally speaking, those cases are inapplicable to this situation because none involved a famous mark like Vagisil, a mark that's on Saturday Night Live and that 90% of the general public know about. None of them involve marks like that. And in all of those cases, none of the marks involved marks that had the same amount of letters for the same products with the same prefix, with the same cadence, with the same cadence, and with the same structure and sound. And there are contrary cases. We cited the communication satellite case, which is a Fourth Circuit case, where ComSat was found confusingly similar to ComSet, even though the prefix com is short for communications. So under that case, certainly the judges, the court's decision stands. On the issue of actual confusion, as the court noted, Combe did a confusion survey. Wolf criticizes that survey as well in its briefs, and same thing here. This is, if we were at trial, perhaps we could argue over the validity of the survey, but this was carefully considered. And the court's reasoning on the survey is very solid. The survey used a design called the Ever-Ready survey design, which has been called the gold standard and has been accepted in this circuit. That showed a significant amount of confusion. Wolf, again, complains about the control, but the control there says that VagiPer was not a good control because it wasn't close enough and it was too foreign sounding. But the evidence shows or the record shows there was no evidence of that. And in fact, to the contrary, in this survey, none of the respondents mentioned that they thought that Vagipure was a foreign sounding mark. So that criticism is invalid. And as the court noted, Wolf can criticize the controls used in the confusion survey, but they didn't test any themselves. And certainly this control did the job of coming as close as possible to the mark without infringing it. So it was a sound design. Wolf also complains that the way the confusion survey was tallied was improper because the expert didn't look at the reasons why people gave for their answers when they confused Vagisil and Vagisan. And that's scientifically invalid. And the record shows that Wolf's own expert conceded that he does not tally confusion results that way. That alone should end the argument, and that's at 450, Joint Appendix 450 in the record. And the court explained it would be highly improper to jettison the scientific purpose of a control cell and instead look at the reasons people gave for their answers. Irrespective, when you analyze the survey the way that Wolf says it should, the results pop up to 21.5%. Wolf has suggested that we should double count the control, in which case the results are 11 to 12%. But even though that would be improper, it still is indicative of confusion. And I refer to the Sarah Lee case, the Fourth Circuit's case, where the court noted that 10 to 12% could be good results. Turning to consumer sophistication, Wolf argues that the court erred by finding that this factor does not favor either party. This is an interesting issue because there was two different types of evidence that was submitted. Wolf submitted evidence that people are careful when they buy a product like this. Holmes submitted evidence that many people are embarrassed by a product like this and the conditions it treats. So they will therefore go into the store and what they call it grab and go or shy to buy. And they grab these products and get out. And they don't spend a lot of time deliberating. Even Wolf's corporate witness admitted that this is a phenomenon. And this is at Joint Appendix 545 to 577. Now, because confusion must be based upon the least sophisticated person, we think this factor should have favored us. But ultimately, the court decided it favors neither party. And so while we disagree with that, there are two plausible interpretations for this factor. And so we therefore cannot show that that was clearly erroneous. And so certainly the court's decision should stand on that and the other factors. I notice my time is running short. One thing I do want to address, in the briefs, Wolf noted that, or stated that there is coexistence of its trademark with Vagisil and Vagisan in the United Kingdom. Even though that is irrelevant based on the Fuji case that we cited in our papers, I do want to point out to the court that there is an ongoing case in the United Kingdom, and that is not true there. And we note this in our brief. There actually has been confusion there. Again, it's irrelevant, but a point that is worth clarifying. So in conclusion, the main event in this case already happened. It happened in Alexandria, Virginia, and Wolf cannot be and should not be able to relitigate it here. After reviewing and weighing a substantial body of evidence, the district court found that there is a likelihood of confusion between Vagisil and Vagisan. Its analysis was careful, and it looked at the multiple individual confusion factors, which are supported by ample record evidence and are true to fundamental trademark principles. All of those factors are issues of fact. And in the Fourth Circuit, the weighing of those factors is likewise an issue of fact. So when we look at all of the evidence, it is well supported, and one cannot be left with a definite and firm conviction that a mistake was made. There was no mistake made, and therefore the district court's judgment should be affirmed. Thank you.
Thank you, Mr. Ratu. Mr. Panko, you have time in rebuttal.
Thank you, Your Honor. Picking up on the sophistication of consumers factor, both the court and Combe conflate the issue of consumer care or recklessness with shyness or embarrassment. So the court's view was that essentially because consumers may experience some shyness or embarrassment about buying vaginal care products, that essentially they're reckless about buying those products or don't exercise care. But that conclusion is contrary to the law as explained earlier, because in Herbalife and other cases to consider products of this type, these are products that are purchased with a high degree of care. And again, Combs' witness in the TTAB proceeding acknowledged that. And so that factor, as a matter of law, should have been weighed in Wolf's favor. With regard to the strength of the mark, Combs attempts to diminish the third-party evidence that was submitted by Wolf by arguing that none of the marks had the prefix badgie plus the letter S plus a vowel plus a consonant. That argument illustrates precisely how weak the Vagisil mark is and how narrow its scope of protection has become because of the widespread third-party use and registration of Vagi prefix marks. The issue that Combs has is over time, first at birth, when it adopted the mark Vagisil, it selected a conceptually weak mark that had the prefix Vagi for vaginal care products. And then it proceeded to acquiesce in dozens of third-party uses and registrations over the years for Vagi prefix trademarks. And the result now is that over the years, consumers have become conditioned to distinguishing between those marks, including, as I mentioned, other Vagi-S trademarks, including Vagistat, which was sold in the same stores as Vagisil for 34 years without any evidence of consumer confusion. Now, with regard to Vagistat, Combs argues that product, and the court included this as part of its findings, that Vagistat was irrelevant because it was in a different product category. That finding was wrong because they're both vaginal care products. And what the law says is that when you're looking at third-party marks, the products don't need to be identical. They don't need to be both vaginal moisturizers. If they're in the same general category, which these are both vaginal care products, then it's a relevant third-party mark. And Vagistat was particularly relevant, again, because it was sold in the exact same stores next to the Vagisil product for over 3 decades with no evidence of confusion and no objection from Combs. And so there's no reason why Vagisam couldn't likewise coexist. With regard to similarity of the parties' trademarks, it is not a violation of the anti-dissection rule for the court to focus its analysis on the suffix of the parties' trademark. In fact, that's what the law requires when two marks have a descriptive, when they share a descriptive prefix like this. That's what the law says is the required approach to comparing the two marks. And with regard to the actual confusion survey conducted by Mr. Perrette, Combs attempts to defend the control Vagi-Per. As I mentioned in the main portion of my argument, that control was improper because it failed to serve the function of a control, which is to determine whether respondents who answer the question whether they believe the mark Vagisan is put out, who they think it's put out by, whether they really answered the way they did because they expressed confusion or because of something else about the mark, because of the Vagi prefix or something else. And so in order to really get a true gauge of that, what the control should have been is something that had Vagi plus the letter S. And so by doing that, Mr. Perrette would have gotten a true reading of whether any confusion was caused by the Vagi prefix or something else. And that was particularly important here because of the coexistence of other Vagi plus S trademarks over the years: Vagistat, Vagisoothe, Vagisilk, Vagisect, and others. And so that defect in the confusion survey rendered Mr. Perrette's confusion survey unreliable, and the court should have taken the same approach that the Western District of Tennessee did in a similar case, also involving Mr. Perrette, which was the Ducks Unlimited case, which had the same problem. It was a confusion survey. The case there involved 2 duck head marks, and Mr. Perrette's survey used a control that didn't look anything like a duck head. It wasn't similar enough to a duck head. And so the effect was it drove down the result in the control cell and inflated the result in the test cell. And therefore the court in Ducks Limited said that Mr. Perrette's survey was entitled to no weight, and the district court.
And with that, I'll ask the clerk to adjourn court for the day. But let me say before that, if you've argued in the Fourth Circuit before, you know, it's our tradition to come down and greet counsel after argument, which obviously we can't do with our COVID video proceedings. So we look forward to seeing you on another occasion when we can greet you in person. So with that, the clerk will adjourn court till tomorrow and then put the judges in the breakout.
Thank you.
This honorable court stands adjourned until tomorrow. God save the United States and this honorable court.